Welcome to Heald Law Academy, the place where you can quickly learn how to maximise the value of your businesses and safeguard your commercial and personal interests. I'm joined by David Dees, and today we're going to look at a major difficulty that can affect any type of service company, from IT to cleaning services, who may be tendering for major public sector contracts where this involves transferring staff. So what makes these type of contracts so tricky?
The problem is that you might end up with lots of people you don't really want. People are very surprised by this. They're in a situation where they're going for a contract with a major customer and they think that having won the contract that they can put their people in. But unfortunately it's a quirk of TUPE, as we call it, that sometimes they're stuck with all the employees associated with the previous failed incumbent.
That does sound quite quirky. How can that be so?
Well, it's a quirk of the law called Transfer of Undertaking Protection of Employment Regulations, if I've got that right. I think so.
It sounds very complicated.
Lawyers just refer to it as TUPE, T-U-P-E. It's a piece of EU legislation that's become entirely normal in English business life. What happens is when a company or a person buys a business and they transfer the assets of the business, which will include the goodwill and the contracts, they also actually acquire all the employees. The employees transfer automatically.
That can be a good thing and a bad thing. It can be a good thing.
They transfer automatically by operation of law. The individuals can opt out if they want, but in essence, when you buy the business, all the staff come across with you. So you might think, well, that's great. I'm buying a business that I like, I want the people. The example that you've described at the beginning is a rather unintended consequence, I think, of this particular piece of law, because if you're tendering for a contract, you're expecting just to get a contract and then to operate it how you want. But because of the way TUPE works, you can find that you've got all the staff of the people who weren't very good previously. Of course, people who operate at those sorts of government levels know about this and can cater for it. But I think it illustrates the principle, and it's a very important principle, and you can come unstuck if you forget about it.
Why is this the case? Is it to protect people from losing their jobs potentially if the company is acquired by somebody else? Is that the principle of it?
Absolutely right. That's the purpose of it. I'm afraid it's always been part of business life that business owners can be quite ruthless. And what they might do, having had their discussion in the pub or on the golf course, they might say, look, get rid of those people because I don't really like them. I quite like your business, I quite like your product, but those people, I don't like them. Sack them. So that's what they used to do. There used to be a bit of a clear out before a sale transaction. They'd take all the business and all the assets and off they go, make plenty of money. And this was thought to be very unfair on the employees.
That does sound quite unfair.
Well, I'm afraid it happened. And it can happen in, perhaps I gave you quite a ruthless example, but it can happen in less ruthless situations. It might be that there's a perception that some people perhaps don't have the skills for the new business. Maybe they want to get slightly different skills in the business. Either way, the same principle applies. In fact, the law is so strict now that any redundancies or sackings at the time of a transaction can be deemed automatically unfair. So you've got to be really, really careful. If you're buying a business, you need to make sure that the people you're buying from are not surreptitiously firing people, because you may find you've got those employees anyway. And on the other side of the coin, if you're preparing to sell a business, don't try anything devious by trying to clear out your employees. Even if there's weeks or days separated from the transaction, if the employee can go to the employment tribunal and say, the only reason they fired me was because he did this deal with this other person, you can be in the firing line. So you've got to take care.
It seems that it is protecting obviously employees primarily, and rightly so. It wouldn't be fair, as we've mentioned, to lose your job simply because the company's been acquired by other people. But on the flip side of that, say you acquire a company that hasn't been performing very well, and then you're stuck with those employees. You know, what happens then? Do you have a right to dismiss them, or
well,
that's
a very good question, and you've raised really quite a difficult area. There is an exception allowed in the law called an ETO, which is an economic or technical reason.
All the big acronyms coming out.
Well, I probably got the acronym wrong, but in essence what you're looking for is some operational difficulties that enable you, having inquired that body of employees, to make some changes. They've got to be an ETO reason, they've got to be a reason that derives from the operation of your business, that's fair and that can be justified. Lawyers always say steer clear of them because they're very difficult to demonstrate. Employees are normally regarded with greater sympathy by employment tribunals, so you've got to be very, very careful in having brought a business to then start making people redundant. And one of the scenarios that does happen more frequently is if there's a change of location. Often when you buy a business, you might be buying it from another location. Then it's really quite difficult for the staff to travel to the new location. And in those circumstances, you can generally work out some fair redundancy packages and generally manage the situation better.
Who would have to pay those redundancies, the new company or the old company?
The new company is going to be paying those as part of the reconstruction.
And if there was a scenario where employees haven't been performing very well and you do want to make some dismissals, how would you go about proving that it was in fact those employees that weren't performing to the best of their ability or in the best interest of the company? It must be difficult to prove individuals.
Well, really it's not about proving that somebody's done something wrong. What you're supposed to do as a manager of a business is to be looking at your employees and making sure that they're performing properly, and you're supposed to be helping them if they're underperforming and setting targets for them. So what you should really be doing as a responsible employer, whether you're selling or buying, is to manage those employees, and if, having given them appropriate warnings and opportunities to change, they don't improve, then you may be entitled to dismiss them.
So what advice would you have for people acquiring a business and also for employees?
I think if you're acquiring a business, you've got to play by the rules. If you're selling a business and if you're acquiring it, you need to get your heads together. There's consultation that's required. Employees do have the opportunity to refuse to go and work for the new employer. Most people don't make that decision because they want to keep their job, but the consultation part of it, the exchange of information part of it, both very, very important. So the advice is just to follow the rules.
Thanks for clarifying that, David. We hope that you enjoyed today's discussion, and if any of the issues mentioned are affecting your business right now, then simply call David on the number below, and remember to subscribe to all of our videos, and we'll send you news of seminars and other events where Heald Law Academy will be presenting. Bye for now.